Our previous videos looked at serious incidents of misconduct and or criminal conduct that were swept under the carpet by the employer. If you have not seen that, you are welcome to visit my channel. The next series of videos will demonstrate that the opposite is also true, wherein officials were dealt with ruthlessly on minor or unfounded allegations. We'll begin with a matter involving Mr. Phoswane, a senior marine inspector in the Department of Forestry, Fisheries and Environment, who is stationed in Hout Bay, South Africa.
Welcome to my channel and welcome to my village. As you can see, we had a fire in the past couple of days, and there is my village on the other side, and we survived that fire. It was unable to cross the river and get to the village on the other side, and you would recall the first videos were dealing with incidents that were serious enough to warrant investigation and disciplinary measures and probable criminal investigation as well. As I understand, the case against Mr. Phoswane is based on the fact that he was alleged to have stolen a wallet. According to his version, he just found the wallet lying down in the office and he picked it up, and at all material times he had the intention of returning it to the owner, but he took it home for that particular day and forgot to bring it back in the next day, and then the next day resulted into the next week, and then the next week resulted into the next month, but he eventually returned the wallet to its rightful owner without him having been persuaded to do so or having been asked to do so. But nevertheless, during the hearing, he admitted not having taken the wallet. However, the presiding officer failed to ask the necessary question to determine whether the employee was admitting to all the elements of the crime. Of course, at face value, it's clear that that could not have amounted to theft, because theft require intention, but obviously in his case it would appear as if it was negligence. Fast forward, then he was found guilty, and the sanction was that of a dismissal, which he appealed unsuccessful, and then he challenged the dismissal in the bargaining council. The bargaining council found in his favor, by doing so set aside his dismissal. The employer went ahead and bring an application at the labor court to review and set aside the award that was granted in his favor. And in that application, it also make a further application for the suspension of the implementation of the award that was granted in his favor. After the employer wrote to the lawyer and requesting that the employee should not report for duty, on the basis that there was this application, and on top of that, there was this um, further issue of suspending the award. And the lawyer argued that there were no basis for the employee to stay at home pending the outcome of the case. But as it turned out, the employer insisted and kept the employee away from the workplace. And what then follows was the employer who elected to do nothing for over a year. One of the requirements is that an applicant has to file a record of the proceedings that resulted into the decision that is being challenged. And in terms of the rule, that particular record ought to be filed within 60 days, failing which the applicant would be deemed to have withdrawn the application. And in this particular case, it has been over a year now, given that the employer brought the application in August 2023. Now we are in October. It's probably 1 year, 2 months. The employer has failed to file that record, which means technically the case is non-existent. Secondly, once again, in terms of the rules, the case, if there is nothing that is being done for a period of over 3 months, that matter would then be automatically archived. And whichever party wants the matter to carry on, which in this case then would obviously be the respondent, then they would have to make an application and show cause why the matter still need to be heard by the court. In this particular situation, as already said, the employer has done nothing for over a year, have not filed a record, have not filed anything, has done absolutely nothing. Now, Mr. Phoswane's attorney then last month wrote to the employer, telling the employer that the employee would be returning to work because the employer has failed to prosecute the matter for over a year. And for all intents and purposes, the matter is either archived or has been deemed to have been withdrawn. And then the employer responded to this communication first by now accusing the lawyer of not being a representative of Mr. Phoswane. And secondly, sort of request that Mr. Phoswane should not return to work, that he should be told not to return to work. But it's unclear what are the reasons for the employer to make this, or the representative of the employer to make this request, because there is no explanation as to why Mr. Phoswane is expected not to return to work, while there is the award in his favor that set aside his dismissal, which in principle really means that Mr. Phoswane should have been at work the day after that award was handed down. And but the employer seemed to be trying everything just to keep Mr. Phoswane away from work, and without even explaining why he should remain out of work. As I understand, even his supervisors and his superiors have been advised not to allocate him any duties, not to allocate him any workspace, and not to allocate him any tools of the trade. Because as it is argued, he's not entitled to be at work. But from the employer side and on the instructions given to his supervisors is that he is still dismissed. And obviously they know that not to be true because he's not dismissed anymore. His dismissal was set aside and the employer had over a year to challenge and have that set aside, and they have failed. So it would appear the idea is to keep this employee away from work in perpetuity, which is obviously unfair in our democratic system where every person has a right to a speedy trial, which is basically why in the rules of the labor court, there are these safeguards there that are set to ascertain that that right to a speedy trial is observed. And but on the other hand, this creates really a situation of a divide and rule, because now innocent supervisors, they are put now in a situation whereby they have to enforce something that is unlawful and irrational, because it's obviously irrational to just say to a person who has an award to return to work and say that he should not return to work, he should wait, I don't know until when. So this is the kind of stuff that the department seem to be willing to do against certain people. For a wallet, that's probable, if anybody has lost anything, would have been the replacement of perhaps the cards that could have been there if there were any IDs, which is, in my view, is something that Mr. Phoswane was obviously supposed to be punished for, but not to the extent of a dismissal. Now it becomes worse now when the employer carry on for years trying to maintain this dismissal illegally, so that is the distinction that this video sought to make, that there is people who cause loss of millions or potential loss of millions, and the department elects not to even investigate to a point of preventing those who want to investigate from investigating that. And people who really cause embarrassment of the country in the international community, and it is just decided that no, nothing should happen to them, and a simple and insignificant thing like that is keeping a person away from work for over a year, and the suffering that is endured by those that rely onto this official is obviously untold suffering, of which one wonders, I mean, these people that are doing this, whether they really do consider that this, what is the impact or the effect of this in the person's family and in the person's health and well-being. So yeah, that is the end of the video. You can subscribe if you want to,